The debate about the supposed decriminalization of drugs for personal consumption gains a new chapter this year, with the resumption of the trial at the Federal Supreme Court, STF. Contextualizing the debate, understanding the judgment. The process in question, RE from Sao Paulo, does not seek, in theory, the decriminalization of drugs, much less their legalization or indiscriminate release, but rather to declare the constitutionality or not of a specific law provision, based on interference in the sphere of intimacy and private life of the individual, as well as the proportionality and adequacy of criminal law in effectively reprimanding the personal consumption of these substances. Furthermore, it seeks to draw a clear distinction between possession for personal consumption and trafficking, as well as establishing more objective parameters, especially regarding the quantitative aspect of drugs, which allow for better identification of both situations. Perceived risks, concern about the idea of unbridled release. We understand that the way it is being conducted, especially by the media, society is apprehensive about the possibility of a misinterpretation of the ongoing process. The confusion between the decriminalization of drugs, their legalization, among other actions, unfortunately, will generate a perception of general liberation, something that is not under discussion in the STF. Microvictims and macrovictims, broadening the look at social impacts. The user is and will always be one of the biggest, most harmful threats to himself, which here, using victimology concepts, we will call the victim itself, to his family, microvictim, and to the entire society, macrovictim. Naming families as microvictims and society as macrovictim highlights the breadth of impacts. Drug use not only affects the individual, but also affects their family and, consequently, society as a whole. Understanding these dimensions is essential for an informed debate on any decriminalization, recognizing the importance of measures that consider not only the user, but the broader context. Effective fight against drugs versus conviction. The dilemma is not one of the Brazilian Supreme Court, STF, but one of the world for decades. However, before we proceed, it is crucial to understand that this is an issue that goes beyond the individual conviction of ministers, encompassing a historical difficulty in building a consolidated position on the topic. This complexity should not be interpreted as a lack of certainty, but rather as a reflection of a multifaceted debate that requires careful analysis. With all possible respects, the biggest mistake made by the Brazilian Supreme Court in this judgment lies precisely in the so-called checks and balances between fundamental rights and guarantees that some ministers adopted. Here, unlike what happens, for example, in suicide, the weight of private life no longer supports the counterweight of the collective good, unless, of course, if the user's puffs occurred on a desert island. In all evidence, the prevailing collective legal good is threatened, harmed, to a maximum degree, yet, already anticipating, it would be a serious error to take into account variables such as grams, quantity, or type of drug, quality. If some people are astonished at the treatment given to the prison population in some states, imagine if they went through, or worse, had to live or support their families in places close to the infamous open scenes of drug use by the world. Therefore, proportionally, but momentarily, due to the fragile, inconsistent and conflicting current drug policies adopted around the world, the use of criminal law in dealing with this issue is still appropriate. But, just for now, as we will see here on the channel. Follow, participate, like, subscribe.